Good morning, everybody. Today is Tuesday, August 11th, and my name is Sandy Andre, and I'm joined by my colleague, Rebecca Strauss. And we are here this morning to talk with you as part of our COVID-19 Response Team webinar series. And our topic this morning is related to the Families First Coronavirus Response Act Regulations Update, and to talk about Michigan's new Executive Order 166. So today's topics include updates to the FFCRA regulations as a result of a court case in the Southern District of New York. Particularly, there are 4 aspects of the final rule that are implicated by that decision. And then we will spend some time talking about Michigan Executive Order 166, which was issued on Friday and rescinded previous Executive Order 36 that's been in our lives for quite some time. Okay, let's go ahead and dive right in talking about the FFCRA. So just by way of background, I'm sure all of you on the call this morning are well versed in some of these pieces, but just to reacclimate ourselves to what we're talking about. Of course, the Family First Coronavirus Response Act became effective April 1st, currently with an expiration date of December 31st, 2020. It applies to most public sector employers and to all private sector employers with fewer than 500 employees. And the FFCRA contains 2 separate paid leave provisions. One is the Emergency Sick Pay Leave Act, which provides up to 2 weeks of paid leave for any one of 6 COVID-19 virus-related reasons. We'll kind of just colloquially refer to them as virus-related reasons. And the second paid leave component is actually an expansion of the FMLA, which allows for up to 10 weeks of partially paid leave for an eligible employee to care for a child whose school or place of care is closed or childcare is unavailable related to the pandemic. So that's just a very brief overview of what we were all thinking and dealing with when it came on the scene in the spring, and specifically related to school closures and childcare closures, came on the scene right as that was happening here in Michigan. So what is happening now? Next slide, please. As I mentioned in the opening, shortly after the Department of Labor issued their final regulations, the state of New York sued the Department of Labor, claiming that the agency unlawfully denied leave to individuals who were otherwise eligible. So essentially saying, hey, Department of Labor, Congress gave you this directive to implement, to create implementing regulations here that go along with this law, with looking towards kind of a pretty wide breadth of individuals who should be eligible for leave in the circumstances that they should be eligible for leave. And so the state of New York specifically challenged a couple of specific areas, saying these, the regulations or the rules surrounding these particular aspects unfairly kind of narrow how people can take leave or the types of employees that can take leave. And so they specifically challenged a couple pieces. And last week, a judge in the Southern District of New York agreed with the state of New York's challenge, and it invalidated 4 key FFCRA regulations. The work availability requirements, the definition of a healthcare provider, rules related to intermittent leave, and rules related to documentation. And we are going to dive into each of those and talk about what the change was and talk about what that practically means. But as we're talking about that, Rebecca and I want to be really clear today that for employers here in Michigan, the takeaway, I should say the takeaway for employers who are not bound by decisions in the Southern District of New York, for example, the takeaway is not straightforward. There are a number of unknowns related to the impact of that decision, including, of course, whether it's applicable to employers outside of New York, whether the Department of Labor will appeal, whether the Department of Labor will issue new regulations, whether employers need to provide leave consistent with these vacated rules retroactively, right? Meaning we need to pretend that the existing regulation as it's specifically related to these 4 aspects never existed in the way that the DOL said that it did. And so we need to be applying kind of this broader view of these 4 key areas dating all the way back to April 1st. So we understand that that is difficult for you to hear this morning, for us to say. It's not very straightforward. And so it's what's really important here, and we want to be really clear, is that for any employers who are making FFCRA paid leave decisions that implicate any of the 4 aspects invalidated by New York's challenge, it's really important that they contact their employment counsel to discuss the specific situation and the approach that makes sense for that employer to take, because it can vary certainly from employer to employer, and there may even be reasons that it varies related to the types of requests that come along. So certainly the most conservative approach is for all of us to pretend that this court decision applies to all employers, and you can take a broader view of these 4 key aspects, but it is a conversation you should have with employment counsel before you move forward with those decisions. Okay, let's go ahead and dive into each of those 4 key areas, and we'll start with the work availability requirement. So you may remember that the final rule that was issued in April, the DOL took the position that an individual's inability to work must be solely caused by the qualifying condition, right? So the reason I can't work today must be because of one of these 6 reasons. And this was particularly important to all of the Michigan employers on this call back in the spring, when the majority of us were pretty restricted, at least in our on-site operations, related to the stay home, stay safe orders, right? And so sometimes that resulted in employees being laid off or furloughed because remote work wasn't available, whatever those pieces were. So the DOL's position was an employee is excluded from benefits if their employer does not have work for them. The sole reason that an employee must need the leave is because of one of those 6 qualifying reasons. And if somebody doesn't have work available, then they don't need leave from that work. And so if you've been listening to our webinars, you've heard us restate that in a number of different capacities. So we all, that was a really big piece of this puzzle. And so what the New York decision said is that the sole cause of the employee's inability to work does not have to be the qualifying condition. And so this is a really big change. So practically what that means for all of us listening is that if an employee is furloughed or laid off or cannot work on site related to, shutdown orders or something like that, and remote work is not available, but the employee couldn't work anyway for one of those qualifying reasons, the employee would still be entitled to FFCRA leave. So that's a very big change. So again, as we look forward, the place that we're in right now, that's a little bit more straightforward for us to implement as we move forward, but we're certainly not through the economic effects of this pandemic, probably, right? Probably not by a long shot. And so if you are an employer who sees some type of furlough or layoff or restructuring of on-site work where remote work isn't available, this is going to be, and you're kind of within that employee number threshold, right? You're a covered employer. this might be something that might impact you as we look forward as well. So this is a critical piece of something for you to flag to discuss with Employment Counsel. Okay, next slide, please. The second aspect of the final rule that was folded up into the New York Challenge was the definition of healthcare provider, okay? So if you remember, the Department of Labor's position took a very, very broad definition of healthcare provider, and it really focused on employers. So if you are this type of employer, all of your employees are kind of folded into the healthcare provider definition. And the healthcare provider definition is important because the FFCRA says that employers can exclude any employee who is a healthcare provider from eligibility under the paid leave provisions, right? And so we had employers saying, folks applying for leave or whatever the situation was, and employers saying, no, you are a healthcare provider and we have the ability to exclude you from being eligible. And so if you go back, right, and listen to the webinars that we did on these final regulations, we all knew that the definition was very broad. We had all of the, examples that they listed there. But the critical piece here was kind of the reasoning that the Department of Labor provided to us, and that made sense, right? So what the Department of Labor was saying in taking their broad approach was that healthcare providers included any individual who was capable of providing healthcare services that were necessary to combat that public health emergency, and taking kind of that broad approach that these individuals were not just medical professionals, but also other workers who were needed to keep those facilities, right, these healthcare facilities, hospitals and similar type of healthcare facilities, well supplied and operational. So it included, maintenance staff and custodial staff, people that were not right in direct patient care. It was folks in those operational and support areas too. So that was the definition of healthcare provider from the DOL. Next slide, please. But then as we transition and we look at the impact of the court's decision, New York, of course, challenged that the definition was overbroad, and the court agreed. So essentially saying that the definition really should be linked to the type of employee rather than the type of employer. And so what probably makes more sense from the court's opinion, or what the court is saying, is that it depends on the employee's job duties. What is that employee doing that would help me determine if they are a healthcare provider or not? We talked a couple of slides ago about a number of the unknowns related to this decision, but a particular unknown related to this aspect is that although the court said that that definition is too broad, it didn't replace the definition saying, well, that's the wrong definition, here's the right one, or even give instructions to employers on what the parameters the employer should use going forward when determining what the appropriate scope of the exemption is. So that's particularly difficult. For now, there's a couple avenues that seem safe, and I'm using air quotes. You can't see me doing that, but I am. Seems safe in terms of if you want to take the approach that this decision does apply to you, there's a couple of avenues that seem like a generally safe route. One, we're not unfamiliar kind of with this healthcare provider definition, right? We know, for those of us who are familiar with the regular FMLA, right, not the expanded version, but the regular FMLA, we know that the term healthcare provider is defined there, and we're talking about the types of persons who can certify an individual's serious health condition in that capacity, right? So we know we've got the Department of Labor who oversees the FMLA, and the Department of Labor who's overseeing the FFCRA. It seems like a safe route to say, okay, well, at least the folks who are folded up in the healthcare provider definition under the FMLA are safe folks for us to consider excluded under the FFCRA. But as we mentioned, there's value in discussing the strategy you want to take with your employment counsel before you decide to exclude any employee under that provision, of course, because there are several frontline health care providers that aren't included in that FMLA definition of healthcare provider that an organization may want to exclude and may make sense for them to exclude. For example, a registered nurse is not included in the FMLA's definition of healthcare provider, and certainly there could be an argument that the FFCRA, when Congress passed it, they certainly intended for a position like an RN to be included in the group that an employer could exclude because those employees were needed on the front lines to fight the pandemic. So that's just one example of the kind of conversation you would want to have with employment counsel when you're determining what approach to take, okay? Let's go ahead and move to the next. So the next aspect that the court took a look at was related to intermittent leave. So if you remember, in the beginning, before we got the final rule, there was some confusion or question related to intermittent leave, whether it was going to be permitted for all of the reasons taken under emergency paid sick leave and expanded FMLA, or if only some, so on and so forth. So essentially, the final rule, as it was written by the DOL, they took the position that for employees who are working remotely, excuse me, intermittent leave could be taken for any of the covered reasons. But for folks who were working on site, the only permissible reason an employee could take intermittent leave was related to care of a child, related to the child's school or place of care closure, or child care unavailability. And the reason related to that was specifically related to mitigation of spreading the virus, right? So they said, in an effort to limit the risk that an employee might spread COVID-19 to other employees, intermittent leave should be limited to certain situations, the ones that we just talked about, but also contained an additional caveat that said employers must consent before an employee can take intermittent leave. And so the state of New York challenged that piece, and the court determined that a couple of things. One, they agreed with the Department of Labor that it absolutely made sense that intermittent leave should be limited only to certain situations that were related to limiting the risk of spreading the virus. So what stays intact here is folks working on site, the only permissible reason for intermittent leave is related to care of a child, related to school and place of care closure. And if you're working remotely, intermittent leave can be taken for any of the covered reasons. But the piece that comes out, right, so the court said where intermittent leave is permitted, employer consent is not required. So the employer no longer has to agree to the employee's proposed intermittent leave schedule, right? So presuming that your employee follows all of the documentation and notice, all of those pieces, types of requirements that are held within FFCRA, and you're a covered employer, they're an eligible employee, they're taking it for a covered reason, all of those pieces, they are entitled to take that time intermittently regardless of whether the employer is consenting. And that piece is about to become a particularly hot topic, perhaps as we look forward to public school closures, right? As we head into fall, either closures to in-person learning or hybrid plans or whatever those pieces are. As you sit here today, you may have a population of your employees who are looking at needing to take that leave, and you need to think about now, okay, before I had the ability to say yay or nay based on the schedule that was being proposed in a conservative read of New York's decision, right? If that's the strategy you want to take to say, okay, that consent piece is no longer required, so what are we going to do as we look at a potential influx of requests? Okay, let's go ahead and move on to the fourth aspect that the court invalidated, and that was the documentation requirement. So some good news here. There's a temporal kind of proximity piece here that was changed, but the documentation in terms of what an employer should be collecting, what information the employer should be collecting from the employee to substantiate the reason for leave, that is unchanged, okay? So as written before the challenge, the Department of Labor's position was that employees were required to submit documentation substantiating the employee's need for leave prior to taking the FFCRA leave, and the court said the documentation to substantiate leave is fine. However, an employer can no longer require that the employee submit that documentation prior to taking the leave. So the employee now has the ability to kind of submit those things at the same time or immediately thereafter, right, from the first workday missed. It's certainly still appropriate for the employer to require all of those other reasonable notice type of requirements that they were permitted to do all along. It's really just the documentation that substantiates that need for leave cannot be required prior to. And there are certainly situational reasons, right, for an employee that would be taking leave that makes a lot of sense. That it's only that, you know, these situations are kind of quickly and fast moving. And so that's part of the reason the court landed in that direction. Let's go ahead and switch to the next slide. And Rebecca is going to talk a little bit about some of the practical considerations related to this decision.
Hi guys, good morning. I'm so happy to be with you. I haven't done one of these morning webinars in a while. So even though I can't see you or hear your voices, I can feel you on the other end of the phone, and it's really great to be with you. I am in my actual office this morning, which is another reason I sound so chipper. I'm talking to you on a real phone, not on a cell phone. Let's talk about the hot topic of the day, which is what to do now that we're looking forward towards the fall and school. The majority of the questions that have come in already on this webinar have been about schools, and frankly, the majority of calls that I've taken over the past 2 weeks have been about the school situation, so we know this is a hot topic. First of all, let's talk about the question that Frederica asked, but it was also part of my notes to talk to you about. Is someone eligible for FFCRA in a variety of different circumstances, depending on what their particular school district is offering? So let's just go through all the different scenarios that I'm familiar with here in West Michigan with what schools are doing and just give you the answers. Okay, so Frederica's specific question is if the schools are open and it is your choice whether you want to send your child to school or keep them home and teach them virtually. Are you eligible for FFCRA leave? The answer is no, because the school is open. So you have that choice. Therefore, you do not need leave to be home with your child. That sounds like a cold answer, perhaps, to some of you on this call, but we think that is the answer. And Sandy will interrupt me at any time if she disagrees with me. Some local school districts are going all virtual. In other words, there is no choice for your child to be in the school building. They must stay home and take their classes virtually. The Department of Labor has actually spoken to this question directly in their latest iteration of their Q&A. And they have confirmed that parents in this situation are entitled to FFCRA leave, because even though the schools are open, and like Sandy, I'm using air quotes, you can't see them, the schools are open in that they're doing something and teaching your children virtually, but the buildings, the physical buildings are closed and not available for your children to be at during the day. So those folks would qualify for FFCRA. What about something a local school district is doing where they have gone for the upper level kids, not all, elementaries going in person. Middle and high school is all virtual education. However, the school buildings, the middle schools and high schools are physically open, and children are allowed to be in the buildings while they are doing their virtual learning. I don't know if some of you have heard about this. This is actually a school district that my children attend, so I know firsthand that that is a choice that at least one school district has made. The teachers will not be teaching in the schools, but there will be adults supervising children. There will be emotional, social support in place for children that use those supports in the school building. There will be food available, but they will be on their school-issued Chromebooks, just like the kids sitting in their bedrooms at home, and the teachers will be teaching them remotely. They will not see a teacher in the school building. We think that if that is your employee's situation, that they would not qualify for the FFCRA because the physical school building is open for their children to attend. They have the choice, in other words, of having their children out of the house and supervised by an adult during school hours, which means they do not need leave to do that. I hope that that makes sense to all of you. Another question that's been coming up in just private client calls and also on this webinar is what about intermittent leave for a parent who is working from home whose child's school is only offered virtually? Okay, does that make sense to everyone? If it's only virtually, and I think that came in the chat. Yes, this is from Nina in the chat room. If an employee's position does allow for working from home full-time, do we have to provide EFMLA if the employee feels they are unable to work and provide care for their child, including online school? The answer is yes. That employee would qualify for FFCRA if their school district does not offer any in-school option. Some school districts, particularly for younger children, are requiring a parent to be with the child during the virtual learning experience. So obviously that employee cannot be working and doing that with their child at the same time. Now, a full confession mode here, both Sandy and I, our husbands both work, so we are in dual income homes with school-age children. So the issue of school and what to do this fall certainly hits close to home, as it does for a lot of you personally. And for all of you, it hits close to home for a lot of your employees. The reality is, what is the difference between this fall and last spring? Last spring, we didn't see a whole lot of employees asking for leave because their kids' schools were closed. They tried to juggle it, right? And it was exhausting. And the reality is, if you had young children and your spouse was also working, you and your spouse were juggling the childcare, and you probably weren't working as much, right? And again, it was exhausting and stressful. We think what's happening this fall is now we all have had time to realize how exhausting that is, how unworkable that is for some families to actually think they're going to work full-time and assist their children doing virtual school all day. And so they are more upfront about the situation with their employers and saying, look, I can't make this work for a whole semester or a whole year. You know, last spring, we were all in emergency crisis mode, but now it's time to get honest, and the reality is I can really only work 30 hours a week or 25 hours a week because of these obligations to my child or my children. So, so what to do for employers? This is causing a lot of stress for employers because a lot of parents need this leave, either full-time leave or intermittent leave, which is going to have the impact on your workforce, right? I phrased that incorrectly. It's going to impact your workforce. There are going to be less people available to work on any given day. That is the reality of it. We do not have a magic bullet for you on that, a magic solution that's going to make it all okay, but you should get your heads around the fact that this is going to be a fact of life. Another fact we have to get used to is whatever folks are thinking right now about what their schools are doing and what kind of leave they need could change on a dime, right? There's one outbreak at the school, the whole school closes down for 2 weeks, bam. The parent that didn't think they needed leave because their kids were back in school now all of a sudden needs leave. And we're going to have to be able to move quickly and deal with those situations as they come up, because they are guaranteed to come up. So that's what we have to say about schools. One thing you may want to consider for planning purposes, again, though understanding it could change at any moment, is perhaps polling your employees about if they think they're going to need leave or intermittent leave for child care in the fall. You can't hold them to those. However they answer, you can't hold them to that, because that would be a violation of the FFCRA to say you need to tell me by August 12th if you need leave or not. However, as long as you are clear of it, their answers are not binding. You're just trying to plan, right? You're just trying to plan for staffing, and you're just trying to get your head around what the fall may look like. I think that's a fair question to ask, a fair poll for your employees. But again, they can always change their mind later. I think that covers the questions in the chat box and the Q&A about schools. Sandy, did I miss anything?
A couple more have popped up, just wanting to confirm the length of time, right, that it's still just 12 weeks. For example, if they used 8 weeks before, they've got 4 weeks left, it's still that cap. And the answer to that is yes, right? So it's under emergency paid sick leave, it's 2 weeks of partial pay related to the school closure reason. In the expanded FMLA, it's 10 weeks of partial pay, right? But that folds in to the, what I'll air quotes, regular FMLA allotment. So the question here is, what happens after 12 weeks for these parents? And that's exactly the big question here. That in terms of FFCRA, we know that that's the limit on it right now. We don't necessarily know of anything that's looking at expanding the expiration date or adding more time, but Dana has hit the nail on the head here, right? That regardless of whether employees have leave time available, you're about to have a lot of employees with a need for leave. And so from an employment standpoint and a staffing standpoint, an employee relations standpoint, all of those pieces, you want to start to think about what your organization can do to keep these folks supported and in the workforce to the extent that you can, knowing that although when FFCR came out in April, we were looking at 12/31 and we thought, oh, well, we'll all be through this by now. A little bit more of a long-term reality is setting in for those of us with school-age kiddos, and so that's the big question. And so, like as Rebecca mentioned, I don't have a golden answer for you, but from an organizational standpoint, it makes sense to start to think about, okay, once we're past the point of everyone exhausting their protected time, what is our next step?
So, Sandy, I think that highlights the crazy time we're living in when answers to questions like that are, well, this is the law right now. But we make no promises as to what the law may be a month from now. I don't think any other time in my life as a lawyer I've answered questions like that. But I would not be, just to build on what Sandy said, I would not be surprised if Congress expanded it. Certainly past December, but also maybe even expanded the total amount of leave available. That would not be shocking to me. If that happened, we would tell you right away. But for now, right, it's that 12 weeks. Hey, Sandy, here's a question from Rio. I'll let you take it. Can you clarify what you mean by intermittent leave? Does that allow a parent to use 8 hours of leave a week if they can only reasonably work 32 hours?
Right, absolutely, yes. So if you are taking the leave for the child care school closure related reason and you're saying, okay, I need 2 hours a day or whatever that schedule looks like because of this thing I'm doing with my child related to their school closure and related to my ability or the requirement that I need to care for them and I'm the only one available to do so here at home. Yes, absolutely. That's exactly what it would look like. 2 hours a day or 3 hours this day, 2 hours the next day, whatever those pieces look like. So exactly that, kind of this, what I'll air quotes again, kind of this flexible schedule. And so then they would burn, 2 hours a day towards that 10-week partial pay allotment under expanded FMLA.
And if they only use 2 hours a day, that 10 weeks of leave, or really 12 weeks, could last for quite some time. Certainly take them through.
Yes, yep, problems. Exactly, yep.
So Heather has asked if we can deny EFMLA for critical employees. I think the answer to that is no, unless they qualify as healthcare providers. So if you're not a healthcare employer, Heather, and you don't employ healthcare providers, the answer is no. And you may be thinking of FMLA key employee exceptions, but Sandy, I don't remember that as part of the EFMLA. Do you?
Nope. So remember, under both of the provisions, there's an exclusion for healthcare providers. Remember, we just talked about what kind of happened with that definition with this New York decision, but also a definition that remained intact, an exclusion for emergency responders. And that definition still is pretty broad. So to the extent that you're talking about folks in either of those categories, you can exclude individuals for some of the paid leave provisions, but the specific term kind of critical infrastructure or essential workers, that term is not in the FFCRA context. We use that in lots of different places, even here in Michigan, in some of our executive orders. But unless your folks fall into one of those very specific FFCRA exclusions, it's not a broad brush exclusion.
Okay, I have, let's address one more question and then we'll get back to the webinar and then address more questions after the prepared material. But this is, I think, a really interesting one that raises a lot of issues. This is from Anonymous. So someone has picked up on the fact that we're using people's names and answering questions. So Anonymous, if an employee chooses virtual learning when their child's school offers both virtual and in-person education, I understand the employee is not eligible for FFCRA. That's correct. Here comes the question. What do you recommend if the employee refuses to work due to the child being home for online learning? So the family has chosen the online option and they cannot work for at least part of the day or part of the week because of that, or maybe the whole week. So my first question is, why did they choose virtual learning for their child? If it is a generalized anxiety about the state of the world and COVID, you can then choose to either give them a leave of absence intermittently or not. You can require them to use their PTO. You can apply your regular PTO and absenteeism policy, which is once you run out of PTO, you cannot be gone from work any longer. You can, the softer approach here, of course, is to maybe not pay them for that time they don't want to work, but give them a leave of absence during this time to allow them to be home with their child. Remember, there's going to be a lot of parents, a lot of your workforce in a similar situation. And once COVID passes, you're going to need everyone back and fully on board, right, and ramp back up. So that's a case-by-case choice for you, whether it's worth it to lose this employee completely by saying, no, I'm sorry, you'll lose your job because you're all out of PTO and vacation time, et cetera, or whether you will give them some sort of unpaid leave to allow them to stay home, and then when all of this passes, ramp back up in your work site. Now, back to the question, why do they need to choose this virtual option for their child, or why do they want to? If it is because the child is high risk, has a medical condition, something like that, the employee could qualify for traditional FMLA, possibly, right? You would need to go through all the verification process that you would normally for FMLA, but that could potentially, depending on how the physicians, the physician answers the questions, could potentially be leave necessary to take care of a family member with a serious medical condition. So there is an argument that that could qualify for regular FMLA. What if it is because the parent, your employee, has a medical condition that makes them high risk for becoming seriously ill for COVID? So they do not want to send their child to school because they don't want their child to bring home COVID. That could be, offering them a leave could be an accommodation under the ADA. So in this situation, the first question to ask is why, right? Why did you choose the virtual option for your child? And then once you have that answer, you can take it from there. Okay, Sandy, you think we've got lots more questions, but how do you feel about moving on and then answering the rest of the questions at the end?
Perfect.
Good. Okay, let's talk about EO-166. So the two hot topics right now are back to school and EO-166. Those are the two things on everyone's minds. So another little Friday gift from Governor Whitmer right before an absolutely beautiful weekend. I think there was a collective groan from all of us here at Miller Johnson and probably all of you too. Now you had to read this and deal with this. So 166 rescinds EO-36. EO-36 has been effective for a really long time. Most EOs with numbers that small have been rescinded by now. So we figured this was coming at some point. All of you on this call, I'm sure, are familiar already with EO-36. That talks about when employees stay home if they have symptoms or if they've been in close contact with someone with symptoms, and that you can't discharge or discipline an employee for doing that. So new EO-166 was effective immediately, changed EO-36 in the following ways. First of all, it expanded the primary symptoms of COVID-19, and it expanded them, in my humble opinion, dramatically. So now the symptoms are fever, sore throat, new uncontrolled cough that causes difficulty breathing. Okay, that's all. The cough and the breathing is now combined into one symptom. Diarrhea, vomiting, abdominal pain, new onset of severe headache, new loss of taste or smell. So in particular, the abdominal pain and diarrhea are really, again, in my humble opinion, broad expansions of the definition, because as we know, employees can have a bout of either one of those things, frankly, on a fairly regular basis, based on what they ate for lunch, all sorts of reasons that have nothing to do with COVID. But now these are symptoms under EO-166. Note that if you are in the restaurant industry, the listing of symptoms is different. We won't go into detail there because that doesn't affect a whole lot of you on the call, but just note that. So because the symptoms have been updated, what does that mean for your daily questionnaires? Okay. we have to update our daily questionnaires. That's the uncomfortable truth. For those of you that have subscribed to the Miller-Johnson Resource Center, we are on it. We are updating not just the questionnaire forms, but our COVID-19 plans and every other document that is implicated by EO-166. So now, instead of just asking for fever, cough, and breathing, now we have to ask if anyone has suffered recently from any of these symptoms. Next slide, please. Another update with EO-166 under the new executive order, employees should stay home until 24 hours have passed since the resolution of their fever, and 10 days, that's an update from 7 days, right? 10 days have passed since symptoms first appeared or since they were first swabbed for the test that yielded possible results and their other symptoms have improved. Notice the executive order uses the word improved, not fully resolved. So obviously that can be subjective. We're going to get to the number one question about EO-166 towards the end of this, which is what about a negative COVID-19 test? We will handle that at the end because there's lots of questions about that. But for now, suffice to say that the executive order eliminated the negative COVID-19 test as a reason to come back to work. No longer there. You could have a negative COVID-19 test and still be entitled to stay home under EO-166. Some of you may be wondering why. Right? What was the reason for that? I do not know. I can't answer that question. I don't know if Sandy can answer that question. But there is no doubt that that negative COVID-19 test element for return to work has been removed from EO-160. Right. Okay. Do you know why, Sandy? Because I haven't been able to find an explanation.
I haven't found any explanations. I have my own thoughts, and one of them is related to the duration of the incubation period for COVID-19, right? So again, just as my own speculation here, I'm not a public health expert, and I've certainly not seen anything like this issued, in a press release from the state of Michigan. But to the extent that, I'm in close contact with somebody, or I start to feel symptoms and I get swabbed today and it's negative, perhaps there's some thinking that negative isn't really a negative. It's just, I'm still where I am in the incubation period, and it wouldn't trigger a positive test. Seems unlikely. If I'm a person who's experiencing symptoms, it would trigger a negative test. But that's the only type of reasoning I can kind of think of. So I don't know.
All right, we are all equally confused, but there's no mistaking what the new EO actually does by eliminating that provision and the headache that causes all of you. Because once again, we have to face the uncomfortable fact that this means that people are entitled to be out of the workforce longer than they might otherwise have been. Okay, next slide, please. Another change has to do with the definition of close contact. It clarifies that close contact is within 6 feet or 15 minutes. This probably surprises a lot of your friends, family, and employees who believe that if they pass someone by right, on a jogging path, that now that they are exposed. It's 6 feet or 15 minutes or longer. The new EO expands the definition of workers who are exempted from this close contact quarantine. Now exempted are EMTs and workers in adult foster care. The new EO does not change the 14-day quarantine requirement for being in close contact with a symptomatic individual or a confirmed positive case. So that rule stands, okay, so no change there. Next slide, please. The prohibition in EO 36 against an employer an employer disciplining or discharging an employee for failure to document their need for leave under this EO. That has been removed. So what is the takeaway? Employers may you can take your ordinary and traditional steps to ask for a substantiation of an employee's need for leave. We already had one question come in, Sandy, while you were presenting, so I was able to take a look at it. And I don't have it right up in front of me any longer, so I don't remember who asked it or the exact words. But the question was essentially, what does documentation look like in the close contact area? What documentation could we ask for? What documentation could an employee actually have? The reality is, in a lot of cases, they wouldn't have any. So you have to be reasonable and fair. And I know everyone wants bright lines here, but the reality is you have to be reasonable and fair. So if someone tells you they've been in close contact and the reason makes sense and you can follow up on the actual reason, but they don't have documentation from a doctor, I think you're going to have to allow them to stay home under the EO. Remember that the public policy purpose behind EO-166 is to stay home when in doubt, right? The government wants as many people to stay home as possible as a transmission reduction strategy. And while that is extremely frustrating for employers, it's a whole lot better than a total lockdown. This is how I rationalized it yesterday. The alternative is we go to total lockdown again. This way, yes, a lot more people are out of the workforce than we'd like, and it causes us trouble from an HR point of view, but at least most of our people can be back to work. So those are the changes under EO-166. Next slide, please. We put on the next slide the questions that came in before the webinar. So remember, for this webinar and any other webinar like this that you may attend in the future, you have the option of submitting questions prior to the webinar. We've gotten lots more during the webinar, but these are the ones that came in beforehand. They're all very similar and have to deal with the negative COVID-19 test. Can an employee that has symptoms but test negative for COVID-19 return to work prior to 10 days? So that is an interesting question. Under EO-166, you cannot require them to return to work, right? They have the right under EO-166 to continue to stay home. Now, what if they want to come to work? What if, for instance, they had abdominal pain? They know it's due to something else, let's say Crohn's or something they've been dealing with their whole life. They get a negative COVID-19 test and they say, boss, I'm all out of paid vacation time. I really want to come back. Can you let them? Under EO-161, you have to prevent people from coming to work who have known or suspected, who are a known or suspected case of COVID-19. This person, in my opinion, would not be a known or suspected COVID-19 case, right? They would not be known because their COVID-19 test came back negative. And suspected is an awfully subjective standard. But given the hypothetical, the example I gave to you, I would not suspect them of having COVID-19, which means you can allow them back to work, but they are entitled to stay home if that's what they would like to do. Next question, can an employee with symptoms return to work after receiving a negative test? Okay, so that's just about the same question and answer as the one before. If an employee answers yes to having a symptom and then tests negative, do they remain at home? How long? So same, basically the same question, right? If they have the symptoms, the EO-166 does not care about a negative test anymore. They have the right to remain home. If they want to come to work, they can, so long as you do not know or suspect they have COVID-19. Unfortunately, EO-166 in that regard has made things more complicated than they need to be, but so be it. Okay, that is, next slide, I believe, just asked for additional questions. So let's get to the additional questions in the final 5 minutes of our time together today. Anonymous says, I thought we couldn't ask for documentation from a healthcare provider. Under EO-36, you couldn't. Under EO-166, you can. Okay, another anonymous, if an employee exhibits 2 of the primary symptoms other than fever on Monday but feels better on Wednesday, they still have to wait 10 days before they return to work and not return to work when the symptoms are gone. That is correct. That is correct. The quarantine period here is longer than any of you would like, is my guess. But remember, the public health perspective is to keep as many people home as possible. Okay, Sandy, here's one for you from Karen. If an employee was in close contact but does not have symptoms, they've been tested and the result was negative. I'm assuming that's the employee who was tested. The employee was tested and came back with a negative result. Can the employee return to work if they want to?
Right, so a couple things here. Really, the person testing negative that is most helpful, that would be most helpful in getting the employee back to work would be whoever they were in close contact with. So once that close contact test negative, then we know that this person wasn't exposed, to a confirmed case, or that person is well again, or whatever the situation is. And then remember, it's just 14 days from last contact. So if it was a week ago and I just found out today, it's not 14 days from today, it's 14 days from the date of close contact. But to specifically address the question, no, the employee testing negative is not the limiting factor here. It's not the trigger to get the employee back to work.
Excellent. I got another one for you. Can we force an employee to use FFCRA? Force is in air quotes, by the way. Can we force an employee to use FFCRA if the type of work they do is not really conducive to remote work, because the children cause an atmosphere not good for a customer service call, for instance? What do you think?
I think this is a conversation, right, that you talk to the employee about the job duties, and you talk to them about the pieces that are not conducive to remote work, whatever, right? So this is more of a performance issue, to be blunt, that it's not that the job maybe isn't conducive to it, it's to some of the other things in the atmosphere going on that make it not conducive. And so rather than right, talking about a performance conversation or talking to somebody about performance discipline, I think it makes a lot of sense to talk to them about whether a leave of absence might make sense for them, to say, hey, we're a covered employer, you're an eligible employee, this is a paid leave, this is something that's available to you, that is here, and you need to be the initiating party there. Or we can put you off on an unpaid leave if they don't want to initiate it. But otherwise, it's not, you don't need to change your performance standards necessarily, and you can deal with that situation. But I think coming at it from a conversation about the concerns and the reasons for those concerns, I think will hopefully lead everybody down a good path that the employee then chooses to use leave available to them rather than forcing performance conversations.
Okay, we are running out of time, so we're just going to answer a few more, and then we will respond to other questions directly. If you did not ask anonymously. If you use your name, we can email you. I'm going to answer this one from Anonymous because it's a Fair Labor Standards Act question, which, as a lot of you know, is my first love, the Fair Labor Standards Act. So this question from Anonymous: what about salary remote workers working from home? How does the pay look if they choose to teach their kids for 2 hours each day from home? Do you treat them hourly and pay 100% for the 6 hours they work and 2/3 for the 2 hours they are watching and teaching their children? Okay. If these are salary exempt workers, the question uses the word salary, not the term exempt. If they are exempt, you need to pay them for the entire work week if they work at all. So they actually don't need FFCRA leave because if they work at all, they get paid for the whole week. Now, if that makes your head explode thinking about that, you can certainly convert exempt employees to non-exempt status, right, and then just pay them for the hours they work, and then they take leave for the hours that they do not work. But as long as they are exempt, they can choose to forego the FFCRA and just get paid their full day, or their full week rather, because they are working part of the day. If they say, I would like FFCRA leave for part of the day, maybe they don't realize what I just told you. So they have requested intermittent FFCRA leave, then yes, the question is correct. You prorate their pay. It's really by the week, right? So you would pay them their full salary for prorated at 6 hours a day, and I can't do math publicly. I try not to, but I think that's 75% perhaps. So you would pay them 75% of their weekly salary, and then you would give them the reduced FFCRA pay for the other 25%. All right, Sandy, last, I'm going to say a set of questions, because there's a few that came in that are very similar that I will throw to you. It has to do with intermittent leave under the FFCRA and what kind of increments it can be taken in. So first question, can expanded FMLA be offered in hours increments? Next question, can it be restricted to 4-hour or 8-hour blocks?
To be fair, as I'm looking at the final rule here, a lot of the final rule increment language was specifically linked to the employer consent piece of the intermittent leave. So I would say that there's a little bit of gray there, but generally, right, if we think about kind of falling back on what we know about regular FMLA and kind of applying that to FFCRA, yes, right? So you can require your employees to burn, right, if I need an hour of time or something like that, but we require, 4-hour increments, you can make those pieces go together. But I'll be very honest with you and say that some of the court's decision on the employer consent piece make that a little bit gray.
Excellent. Although none of us like gray answers, but that is the answer. We are the bearer of bad news on that. So it is already 9:04. We will let you get back to your day. If you asked questions that we did not have a chance to answer, we will try to email you an answer in the next day or two. We hope you all continue to be healthy, be well, until we talk to you again soon. Thank you.